All right, I did my research on Grutter versus Bollinger, and this case focused on Barbara Grutter, who in 1997 applied for law school at the University of Michigan. She was denied, and then she claimed that her denial was because she was white. She was discriminated on due to her race. She stated that the university used race as a predominant factor in the admission decisions, and because of that, she didn't earn enough of the points because she was white to get her in. The University of Michigan argued the other way, that diversity is important to the college experience for all students, and they also sought to create something called a critical mass of minority students. They didn't want a quota, so a certain number of minority students, but they also didn't want like the token minority student that represented their entire population and had to act as that spokesperson. The lower courts, the Eastern District Court of Michigan, found that the use of race as an admission factor was completely unlawful, in violation of the 14th Amendment, and sided with Grutter. And then it went to the Sixth Circuit Court, and they totally reversed the decision. They cited that in a previous case, the University of California versus Bakke established diversity as a compelling state interest, allowing race to play a factor in making those decisions. It got appealed to the Supreme Court, and the Supreme Court heard it. It was the first affirmative action case they had heard since the Bakke case about 25 years before. And they affirmed the Sixth Circuit Court decision. They upheld U of M's admission policy, stating that because it wasn't a quota system, that it was legal. In Bakke, they said that a quota system is not legal, but you can use it as a plus points system. So if people are granted a certain number of points for their GPA or their LSAT score, you can also grant them a certain number of points for their race. The court decided to clarify the University of California versus Bakke decision, stating that race is allowed as long as it's with other factors. The decision was 5-4, though, so it was not unanimous. It was pretty split right down the middle. And I found this very strange, but they noted in the future, and they specifically said 25 years, that affirmative action should no longer be needed. They apparently were extremely hopeful that in 25 years from 2003, so in 10 years from now, that race would no longer matter, that people wouldn't be discriminated on based upon their race. And unless something drastic happens in the next 10 years, I feel like we still need something like this around. So let's revisit that Bakke thing just so we understand what's going on there. So, similar case, this was a white male. He applied to a college and wasn't accepted. He found out that minority students who had lower GPAs and lower GREs were accepted, though. And it was because the University of California used a quota. They had 100 seats, and they set a certain number that 16 seats were completely dedicated to minorities. So if you were the 85th best white person, you weren't getting in because they only allowed 84. The U.S. Supreme Court in this instance found this unlawful, that they set a certain number and then had to meet the quota either way. And they ruled on the whole thing that public universities can use rate to evaluate students, but they can't use a quota system, and race can't be the only factor. So this brings us to, what is affirmative action? Why is it needed? Why is it necessary? Affirmative action is a program designed to redress historical injustices that make a special effort to provide members of underrepresented groups access to educational and employment opportunities. I have this sign hanging in my classroom. Fair isn't everyone getting the same thing. Fair is everyone getting what they will need in order to be successful. And I know that's hard for students to understand, and sometimes even adults to understand, that not everyone starts with the equal playing ground. I always like this picture as a great example of it. We have 3 kids here who all have different needs, all start at different levels. And if we give them all the same access, this person here has better access to the game, where this person here, the blonde, not so much. So instead of giving everybody something equal, we give them something that allows them to have equal playing fields or equal fields of vision in this case. So, relevance to public schools. Obviously, both of these cases were about higher ed, and both of them were about admission into higher ed. And it wasn't even undergrad, both of these were graduate works. Our public schools, we obviously don't recruit students, we don't turn them away. They're the students that we get. From both of these cases, it's been decided that it's in schools and society's best interest to work and interact in diverse environments, and minority students bring a lot to both of those environments. So what does this look like? Well, for teachers need to be aware of their students' level of access and their ability to move forward in life. Now, this could be with any minority group. This doesn't have to just be with race, but teachers are always going to fill different roles in the lives of some students. Some students come to school totally loved, totally taken care of, and they need the education piece, where other students maybe don't have food and they're looking for other things before they can even learn whatever topics we are giving them. So teachers just need to be aware of that, be able to fill those different roles in different students' lives, and also just understand that everybody might need something different. The whole idea behind affirmative action doesn't need to be a government supplied program. It can also just be that a teacher's aware of her need or her students' needs and then responds accordingly to them. Gives them different levels of blocks to stand on so they can see the game. For administrators, those in charge of hiring especially, they need to be aware of the student-teacher population distributions in terms of gender, race, religion, etc. It's always important for students to see themselves represented in the adults that work with them. So again, just like the University of Michigan decision, it doesn't need to be, well, we're just going to hire minorities so white people don't stand a chance in getting hired, but it needs to be looked at as what role can different people fill. And a diverse student population should be represented with a diverse teaching population, a diverse administrative population. We should be representing the students that we work with. So, Grutter versus Bollinger was affirmative action, and I could not believe how optimistic the judges were in stating that we might not need something like this in 25 years. I'm still hopeful that in 10 years we don't need this, but doubtful as well. Thanks.